All right, I think it's about 10, so why don't we get started? We've got a plea and arraignment calendar that has one probation revocation on it and a few inquiries, but we'll dive right in. Position 1 is Lionel Baitman.
Yes, sir. Good morning. How you doing?
I'm all right, Mr. Baitman. Good morning. Appreciate you being here.
Yes, my lawyer, her name is Miss Jeffrey Taylor. She told me to tell you that she was court in the California and she got to be able to we said and she come back.
So the answer is, of course, yes, but Ms. Taylor needs to do that work herself in the future and not make you do that. She needs to reach out to my office. She knows how to do that, to let us know about the conflict. But let me look your case up to make sure she's filed an entry of appearance. When did you talk with her about her being your lawyer?
I've been talking to her. I guess more than a year ago. I talked to her on last week before the case came up.
Okay. She has not yet filed an entry of appearance. That's the magic signal that a lawyer gives to say, I'm officially Mr. Baitman's lawyer. So right now you guys are what I'd call in discussions, but she's not your lawyer. So we can still reschedule to give you some time to hire her if you think by the next time I bring you here, you would have completed the financial arrangements.
Yes, sir. I already gave her the money. I don't know why she didn't get it.
When did you give her the money?
I gave her the money like 4 days ago, sir.
Okay, so it's pretty recent. Got it. All right. So it's not like you gave her the money 2 months ago and she hasn't. Okay, but you feel like whatever number she gave you, you've given her that amount and she said, hey, Mr. Baitman, I'm your lawyer for this case.
Yes, sir.
Okay. I want to make sure we've got, how did you know you had court today?
My wife heard me spending the call with me and she told us well.
Did you get something in the mail?
Yes, sir.
All right. Now you have a second case. Oh, that's going to come to us. That's in non-complex.
They ran everything down. They ran everything curb my stats on one seat. I don't know why they did that, but.
When you say they ran it concurrent, I mean, you haven't resolved that case yet.
No, sir.
Okay. It'll get transferred here because the case you've got here is an older case. And so newer cases come to older cases. So you'll have one judge. Has Ms. Taylor told you she'll handle your other case too?
Yes, sir, as well.
All right. So you've hired her for both cases?
Absolutely.
Absolutely. Okay. Well, let me make sure we've got a good address for you. Does Ms. Taylor have your phone number? She knows how to reach you?
Yes, sir.
Okay. I've got a couple addresses for you. One of them is Terrian Way.
That's where I stay right now.
That's where you stay at right now. Did you used to stay on Alfred Road?
Yes, that's my grandma's house, before she died. It's a common house.
Okay, but if we're sending things to the Terrian Way address, then you'll be getting notice that.
Absolutely, me and my wife live there.
Okay.
Absolutely.
All right, good. Let me check one other thing. So you already had an arraignment on this. I was trying to figure out why this older case was still rattling around. In fact, Ms. Dilligard, of all people, prepared the order that transferred the case from non-complex to Ms. Dilligard here in this courtroom. It's a closed loop. You're what we call a repeat offender. So your criminal history is such that stuff in non-complex comes to a superior court judge and randomly it got sent to me. So that other one, the newer case, that'll come here as well. I'm gonna give you one reset to have Ms. Taylor show up. She can always waive arraignment if that's what she wants to do on your behalf, but we'll bump it one time into January. You'll get something in the mail to that address in Decatur telling you when you need to be here. Unless Ms. Taylor tells you you don't need to be here, you need to show up again so you don't get a bench warrant, okay?
Yes, sir.
But she might agree to do this thing called a waiver of arraignment and then tell you, don't worry, you don't need to come to court. But that's a call for her to make, not for me to make.
Yes, sir.
Any questions about anything?
No, sir.
All right, let me check one more thing about bond and write this number down. Who else lives in your house besides your wife?
You know, first name Max, once we get rid of, we keep stacking the house up. Our first, she got a first name Max, we keep stacking the house up. So
Okay, does she know that you're getting rid of Max?
She don't have a choice.
Interesting. Let's not create a new case for you. Although that would be in DeKalb County, so I wouldn't have to worry about that. Let me find your bond. But no other people in the house. It's you and your wife and Max.
Yeah, that's it.
You feel a little threatened by Max?
No, I'm just tired.
Yeah. Sometimes there's only room for one in that space. So your bond order is okay. The basic stuff, nothing profound. All right, Mr. Baitman, it's nice meeting you. We'll figure out what the deal is with Ms. Taylor, and you will get one final opportunity to make it for arraignment and have Ms. Taylor show up. We'll get that newer case brought in here as well. And I think that's it. Ms. Nix, anything from the state? All right. Any questions, Mr. Baitman?
No, sir.
Okay, you're free to go.
No, this is, sir.
You too. Be nice to Max. All right. Position 2 is Ricky Pierce.
I went and met with Mr. Pierce. He told me he's hiring a Carolyn Lynn.
So Ms. Lynn is on the call, and we're going to bring Mr. Pierce out and have a good conversation about that. Ms. Lynn reached out to Ms. Nelson yesterday to indicate that she had been retained only for bond and nothing more. There was no entry of appearance in the docket, but I need to explain to Mr. Pierce how that works. He doesn't get to have a lawyer for back rubs and another lawyer for bond and another lawyer for mealtime. He gets a lawyer. He can hire a lawyer for everything. Or he can have you, if it's your number, represent him. So if we could bring Mr. Pierce out, please. Good morning, Ms. Lynn. Thank you for being here.
Good morning, Your Honor. Good to be before you, Judge. I did want to speak on it. I'm happy to wait until Mr. Pierce is present, Your Honor.
Oh, definitely. No. And I definitely want to hear from you. We just need to sort out how we're going to manage this situation.
Yes, Judge.
All right, Mr. Pierce, good morning.
Good morning, sir.
I'm Judge McBurney. Your case has been assigned to me, and today is supposed to be your arraignment day, but there's a little confusion swirling around who is going to be representing you.
Okay.
Ms. Lynn is on the screen in front of you. You should be able to see her. She just waved. She reached out to my office yesterday saying that she had been retained to help you with bond, but only bond. She's not filed an entry yet, or at least her entry hasn't hit the docket. We kind of discourage the, hey, I've got a lawyer to help me with just this piece, but not this other stuff. But I also recognize that if you're trying to hire someone, a lawyer might say, if you want help with bond, it costs X. If you want help with more, it costs a whole lot more than X, and you and your family may only have X. And so we can work it that way, but I need to get you your forever lawyer who's going to handle this case from arraignment all the way to a plea or a trial or a dismissal, whatever the final disposition of the case is. There's serious charges. You've got a co-defendant who already has a lawyer. His case has started to move forward. I want yours to catch up with it, because if there is a trial, I would intend to try both you and your co-defendant together, not separate trials, unless I'm required by law to have separate trials. And it could be one of you pleads and then I'm only trying one person. But I am anxious to have your process catch up to Mr. Baker's process. So what I want to start with is you telling me what you think the plan is for representation, because we've got Ms. Lynn on the screen. Behind you is Ms. Rios, who would be appointed to represent you for everything, to include bond. And I just need to work through whether I'm going to be okay with, you know what, you can have your own private attorney for just bond, which I don't know that we're doing today because there's no bond motion, which means the state wasn't put on notice, which means they haven't reached out to Mr. Harris's family to say, you should be here if you want to be heard about bond, because it's important that I hear from the victim's family as well. So I laid a lot on you. Why don't you let me know what you see your representation situation being going forward?
I want to hire Carolyn to represent me. I don't want a public defender.
Okay. Want and ability are two different things. Do you believe that you or your family have the financial wherewithal, the money, to hire Ms. Lynn, not just for bond, which, like I said, she probably quoted you a figure of X, and I don't want to get into what those numbers are, that's private, okay, for bond. I know it will be much bigger than X to say, I'll take it all the way to trial. And Ms. Lynn would need to tell us, and she's going to get a chance to speak in a minute, oh, I'm good, I'll be his trial lawyer as well. But she'd have to say that she's interested in doing that. And assuming she says yes, then I'd need to get a sense from you when you think you and your family or supporters would have that kind of money to put together. Because what won't happen is Ms. Lynn tells you what it will cost to represent for a trial, and you say, Judge, I need a year. We're going to move your case forward, and I will appoint a lawyer to represent you. If at some point you get all that money together, you could always switch, but it's not fair to you to be sitting over at Rice Street for a year. It is not fair to the Harris family to be waiting so you can pull together the coins to get a lawyer. And like I mentioned, I'm pretty focused on keeping you and Mr. Baker moving along together. He has an appointed lawyer. He is not able to afford one, and so he's had a lawyer appointed to represent him. It's obviously a different list, not someone from the public defender's office. It's what we call a conflict defender, but that lawyer is working with Mr. Baker, and I need you to start working with the lawyer too. So your goal is to try to retain Ms. Lynn for everything.
Yes, sir.
Have you or has someone from your family had a conversation with Ms. Lynn about what that would look like financially?
Yes, sir.
Okay. Ms. Lynn, your turn. Tell me what you think is going on in terms of representation and handling Mr. Pierce's case.
Yes, thank you, Your Honor. So representation is fairly new, Judge. You are correct, Your Honor. I was, for financial reasons, retained for the limited purpose of bond around December 10. I did make an attempt to file the entry styled that way, Judge. For some reason, it did not submit through Odyssey. I got the confirmation saying submitted, but it's not reflecting. I think that probably happened for good reason, Your Honor, because in hindsight, I looked back and I said, well, let me reach out to your office, which is what I did yesterday, because I do understand that typically when you represent a person for limited purpose of bond, it's pre-indictment in most cases.
Right.
So when I realized that the entry did not hit the system, I informed Ms. Nelson that I would hold off and inquire to the court this morning what the court would find most efficient. I've had conversation with the family. I've had conversation with Mr. Pierce. We've talked about the financials. And I thought to do it this way in an effort to satisfy both sides, to assist him the best that I can, but to also not inconvenience the court, if that makes sense.
It does, and I want to be clear, this isn't about inconvenience. It's not, oh, I'm frustrated by it. This is all about due process and Mr. Pierce and wanting to make sure he's not stuck because his family can't raise adequate funds to make it work for you, Ms. Lynn, to be the trial attorney and not just the bond attorney.
Yes, I understand, Judge, and I do appreciate that. I hear Mr. Pierce saying that he would like to retain for full representation. If there's not an issue of indigency, which is what I was concerned with, that may be the circumstance. But if there is not, Judge, I am happy to come on fully on board. I would like to know from the court if I file in my full entry, and at some point, and I know this is the companion case, there's a co-defendant. So I understand unless there's a severance, everything that happens with him affects the co-defendant as well. If something happens down the line and there is an issue of indigency, excuse me, would a withdrawal be an option since it's being discussed so early on in order to protect, as you said, Judge, Mr. Pierce's rights?
Right. So that becomes more problematic. And did you follow what her question was, Mr. Pierce?
Yes, sir.
She's inquiring if sometimes a defendant says, hey, I can do a payment plan. I know I'm gonna need to pay you, I'm gonna make a number up, 10, whatever 10 means, over time, but I can only do 2 at a time.
Okay.
And so the lawyer says, that's fine, I'm gonna work with you, and as long as you're paying 2 every month, life is good. And then we get 4 months in and the money runs out. And the lawyer says, but I need 10 to be able to go to trial because there's a lot of time and energy and investment. And I only have 6 right now. And so Ms. Lynn is saying, would she be able to withdraw if for whatever reason the money dried up? That's a hard question for me to answer because if we're 2 weeks away from trial and Ms. Lynn says, you know what, they just didn't come through with that final payment. They're not fair to her, she didn't get fully paid, but also not fair to everyone, Harris family, you, your co-defendant, if we have to say, uh-oh, we need to now get you an appointed lawyer who reasonably is gonna say, well, I can't go to trial in 2 weeks. I gotta get to know Mr. Pierce, I need to look at the case file, I gotta look at all the evidence. And so I'm a little leery or reluctant to say I would bring a private attorney on board who is saying, I'm in as long as I keep getting paid. Some lawyers say up front, hey, you need to give me 10 up front. And if you give me 10, I'm good for the whole thing. Okay. And others say, I know that 10 isn't a reasonable number right now. It's a reasonable number, but you can't do it all at once. And so we'll do 2 and then 2 and then 2, and that money dries up and then everyone gets stuck. That's what I'm not real interested in doing. Does that make sense?
Yeah, it makes perfect sense.
Okay. Ms. Lynn, have you and Mr. Pierce's family had a discussion about what it would take to get you comfortable saying, no, that's enough, so I'm sticking with this through trial?
We have, Judge. It's been some discussions based on some contingent outcomes, and I think that's what's creating the challenge. I think what's happening is, God willing, we're successful on a bond. Mr. Pierce can be released and then he can start contributing, but of course it's all circumstantial.
Yep.
But I don't want to come across to the court that I'm not on board with Mr. Pierce, Your Honor, because I am. I just wanted to, that's why I reached out yesterday to the court. I just wanted to get an idea of how Your Honor would be willing to handle this situation. And if we can't kind of dip our toe until we can get a better feel, I understand, Your Honor, because I know it's a lot of moving parts to this. So I am supportive of Mr. Pierce. I'm here. I'm available. I'm happy to be on board. I just wanted to get a lay of the land of how the court would handle this kind of situation.
Got it. Thank you. Is there someone here for Mr. Pierce who just came in? Several people. Okay. Is there anything you can add on the financial front? Here's what I'm planning on doing, is saying we'll just reset this for about a month. We'll come back in January for this very same event, but it also can be a bond hearing if someone files a bond motion. But what we will do when you come back is handle your arraignment. If there's a bond motion filed, we could have that bond motion. But that'll also be the put up or shut up date where you're able to say, yes, I have retained Ms. Lynn to be my lawyer all the way through. Because if the answer in a month is, I think I will, I might be able to, that means that I'm going to appoint a lawyer to represent you. Ms. Lynn can still do the bond motion. It sounds like she's been retained to do the bond motion.
Okay.
But I want us to get closure on what happens after that bond motion. And if the answer is from you or your family, we don't know yet, or we couldn't afford it, then I'm going to appoint a lawyer so that your case can keep moving forward. And it will be a good lawyer who will move your case forward. You are always free to switch up. So I'm giving you a hypothetical. We're in January and you and your family say, we can't make it work out. So Ms. Lynn's going to do the bond motion and that's it. She's released. She's not your lawyer anymore. You get your appointed lawyer, things are going well, but your family wins the lottery in May. And all of a sudden you could afford Ms. Lynn. You'd be free to say, you know what? I've now hired a lawyer. You can always hire a lawyer at any point. But if that money doesn't arrive, you will have a very experienced lawyer who has tried murders before representing you throughout in case the money doesn't materialize. That way we're moving you forward, which is my goal, that you're not languishing at the jail if you don't get a bond. And we're getting you into court for a trial as soon as is reasonable. So I need to get that lawyer by your side, whether it's Ms. Lynn, because you've been able to pay for her to be there the whole time, or it's a lawyer I appoint for you who will always be there all the time for you. Okay? That makes sense?
Yes, sir.
It means we're not talking about bond today, but we weren't going to do that anyway. That's not on Ms. Lynn. There's not a bond motion yet. But when we reconvene in January, whenever we can, we're going to tackle all those things. We'll talk about bond. We'll talk about representation, and we'll handle the arraignment. Okay?
Yes, sir.
Mr. Abate, anything from the state on this case?
No, Your Honor. Discovery is ready to be served as soon as we know who to serve it to.
Okay. Do not serve it on Ms. Lynn yet. If her entry just says, I'm here for bond right now, let's not complicate things, but we'll get clarity at the next court event, whether that will be Ms. Lynn going forward, and then she can have that evidence.com list link, or whether it'll be Ms. Rios, and it'll be ready to go. Is there, Mr. Baker may have waived his arraignment. I don't remember talking about the case much. I read the warrants and they aren't particularly helpful. Is there anything complicated about discovery?
No, Your Honor. There's just obviously the ballistics are pending after being collected from the scene. They're at the GBI, they're just awaiting testing. But other than that, it's a pretty.
Is this the one that happened on Mitchell Street? Yes. Allegedly? Okay. All right.
The defendant went to steal the dog of the victim.
Okay. All right. That's where we are. Mr. Pierce, do you have any questions about anything we discussed?
No, sir.
Okay. Ms. Lynn, we're going to leave things as they are. You should figure out how to e-file stuff in the docket. I don't know what the hiccup was. If you are filing an entry, if you are filing a bond motion, just make sure that happens in the next week or two so that that's in place. That'll put the state on notice of the bond hearing, and then we will get a calendar date for that bond hearing, arraignment number 2, and sorting out who's going to be representing Mr. Pierce. Does that work for you?
It does, Judge. I'm going to have more discussion with Mr. Pierce and the family to determine how I need to style my entry. I mean, they may be ready to answer me right now. I don't know. I need to call them and talk to them. Yeah. And then once I determine how to style the entry, I will get it filed. Judge, I was filing in the middle of the night, and I think that's when Odyssey does construction on their site.
Right.
because it was lagging a lot. And I think that's what happened. And it was kind of a glitch when it was supposed to actually fire it off. So
Got it.
I won't refile in the middle of the night, and I'll notify your office once I know how I'm filing, Judge.
Sounds good. Thank you, ma'am. If we don't talk, have a good holiday.
Thank you, Your Honor. Same to you. Good to be before you.
All right, bye-bye.
Bye-bye.
Mr. Pierce, that's the situation. So I will see you early next year and we'll try to sort all this out.
All right.
So for those of you who are here for Mr. Pierce, you understand your job is to connect with Ms. Lynn and sort out what you can sort out. It won't work well if when she is back next year, she says, I still don't have an answer from the family. It either is we can afford you or we can't, whatever that number is for the trial piece. Because otherwise we're stuck and I need to move Mr. Pierce's case forward because you know where he's spending every night. There you go. All right.
We have this out this meeting that we shake and we say, stick and stay set.
Okay.
The whole thing for that we're back. Yes, Dave.
I guess I'll just check back in a month to see.
Yeah, you should be at ease on that one. Ms. Cabrera, who was here, hey, she represents the co-defendant, so that would be your co-counsel, if you will. She's got Mr. Baker's case. It's already set down for final plea and trial. That may have to stretch out a little bit if we are keeping them together, which hopefully we can. But I don't want to, in the same way, I don't want to delay things for Mr. Baker because Mr. Pierce is moving slowly.
I count on it probably being here because.
What were you saying?
I would count on it probably being here. It sounds like Bond was a key component to hiring her, but in all candor, he's got 2 escape convictions. So I think Bond maybe not.
Probably don't get a lot of those.
No.
All right. Okay.
2.
I guess we'll see.
Yeah, not just one. All right, Ezekiel Stevens was on for a bond hearing, but we're not doing that because he had his bond revoked because of other trouble he got into while on bond.
We already handled that hearing a couple weeks ago, Judge.
Well, we did, but then it was like, I'm gonna think about things and, oh, she removed it, okay. But we doubly handled it. I know he was here, Ms. Clark was here, but there were some questions about maybe I would modify the conditions so he could be out for the holidays. And then it came to light that there were guns at his house and they were taken from someone else and pointed at someone. And so there's no bond for Mr. Stevens. And that was all coordinated with Ms. Singleton. All right, Xavier Mosley, there's already been a waiver filed by Ms. Wood a couple of weeks ago. He was not brought over, so we'll get a scheduling order out and you can get discovery to Ms. Wood.
Yes, sir.
Great, all right, so that case is moving along.
Yeah, we're just waiting on, obviously, always the ballistics. On this one, we actually have a weapon to compare with.
Okay. Is your office still using a third-party consultant on that, or are we back to relying on the GBI?
We're back to relying on GBI. I believe maybe that could change if additional funds.
There's a budgetary reason. Okay, all right. And is the GBI as backed up as it had been, or did the fact that Fulton pulled out let them catch up a little bit?
They're still backed up, but they seem to give us some priority because of the large number of cases.
Okay. All right. Mr. Jackson, Mario Cladis, is a probation revocation hearing. It's a gang case. Is Mr. Hiles going to be here? Will you be handling it?
It is Mr. House's case. He let me know that he was not going to be available until 10:30. It's now about 10:30,
Okay.
but he did say that this would need a full hearing.
Okay.
So I imagine it will need to be reset for
All right. Well, we want to is Mr. Jackson here?
Yes.
Okay, we'll wait to bring him out. And then Ms. Rios, would you be handling that?
weeks, I went to go talk to him at the jail. I didn't realize it was gonna be a full hearing, but.
Well, we won't do that today, but we'll get all that on in front of Mr. Jackson. Oh, he's got two. All right. Torrance Statum.
Yes, I filed just yesterday a motion to set aside his bench warrant. He was in custody when he missed court.
Okay, so we can bring him out and talk about that in a second. Okay, Sharika Bullock.
So the plea, I just need to go over her rights with her.
All right. And Javaris Matthews.
That's mine, Your Honor. Well, it is mine now.
Hey,
So at the time the calendar was dated, it wasn't, but that's gonna be mine, so.
do you want to talk with him? You know what, he was picked up on a FTA. So I don't know if doesn't look like with the charges it's working out today, but what do you?
I talked to him in general, but I would, waive any formal arraignment.
Let me see where that is. Co-defendant is in federal custody. So today would be an arraignment. So you're gonna waive that. We've got the form if you want to fill that out. That would get your entry in as well. You could kill two birds with one piece of paper. But if you want to do that, I'm happy to engage with Mr. Matthews if you want me to say, hey, but you can manage that. Okay, great.
But I'll do the waiver.
Okay, great. Well, once you've done that, you're good to go. So waive. Schedule. All right, so Ms. Bullock is a plea. You need to talk to her. Mr. Statum, I guess we could bring him out now and do that. And then once we've got Mr. Hiles, we can just reset Jackson. I think that's it. Is there anyone here who thought there was another case they would be hearing about? Oh, okay. Let's bring Mr. Statum out, please. Ms. Miller? Which one is Ms. Miller? Hey, how are you? I'm all right. I'm gonna sign this right now and Deputy Gordon will give it to you. And I hope this goes all right for you.
You got your paperwork?
I do.
Came with a clip, so just don't lose your license. Got it?
Originally arrested. I've been locked up since then.
If I don't see you, happy holidays. I don't know if you get any time off, but hopefully
Me was for
going to Mexico again.
give me 2 for 1 that the judge gave me.
See y'all.
Bye.
This is when we're just-
There's the camp out there right there.
And you've been here since,
Yeah, ma'am.
okay,
Since that original.
yeah, since
that-
here,
Yes,
okay,
ma'am. That-
got it, I see.
Good morning, is it pronounced Statum?
Yes, sir.
All right.
Good morning, Judge.
Good morning. You missed court at plea and arraignment, but Ms. Rios is telling me you were in custody elsewhere.
I
So
have been, yes, sir.
we're gonna talk about that and then figure out how to move your case forward, okay?
Thank you, sir.
All right, so Ms. Rios, plea and arraignment was almost a year ago, January 16th of 2024. And we sounded for Mr. Statum, couldn't find him. Where was he?
He was in Washington State Prison, I believe. I have paperwork. It looks like he was arrested on February 8th, 2023, and has been in continuous custody since. So the paper, he has me one paper with his arrest information, and then
Where was he arrested?
Where was he arrested?
Right here at Fort
Oh,
County.
Fulton County,
In
yeah, it looks
Fulton
like he had
County.
a revocation with Judge Glanville. And
October 20 of last year.
yeah, October 30th,
What
24.
case is that?
The case number is not on here. Oh, is it on here? No, I don't think the case number is on there. Oh, might be it. Let me, hold on. No, that's the disposition. Is this the, let me see.
This first.
Oh, 16 SC 147792.
Okay, it turns out Mr. Statum has another case too. It's old, and we'll just reactivate it. A 22 SC case for entering auto. Apparently you were in drug court
Yes.
and drug court didn't work. So would you work with me or with Judge Kraus? Or did you not do much?
It's Judge Glanville.
Oh, it's Veterans Court. Oh, hence Judge Glanville on the revocation.
Yes,
Okay,
sir.
got it. All right, let me look up the 16 SC. Do you have that info? You may have that, Officer Evans. Was Mr. Statum revoked such that there's no way he could have been in court in January of this year? Thank you. I actually have mail from Mr. Statum in custody when he would have been here. So I'm
Okay.
good. He was clearly in custody. He was trying to get credit for time served in connection with his revocation. All right, so I'll set aside the bench warrant. Did Mr. Statum, I guess, then already have bond in these cases? He must have if he.
There's a bond order, I believe 13,000 total. They never made that, because he was transferred to prison.
Okay,
So that bond is still,
got it. In this, you're talking about in the case that's on the calendar, this criminal damage case.
yes, I
Okay.
don't know about his other case that's still in judicial hold.
Okay, well, we'll work through that at a later date. I just didn't want to mislead Mr. Statum into thinking, hey, I set aside the bench warrant and get out tomorrow. You and Ms. Rios will need to look at both your cases. You want me to give you the other case
Yeah.
number?
Yes.
It's just went away. 22 SC 182038.
Is there a bench warrant on that case too?
If so, I'll lift that. I think it was from even further ago, but I'll set those things aside and we'll work through what's going on with bond, if anything.
Okay.
And you can let us know. I know Mr. Statum was not arraigned in this case. Let me check if there was ever an arraignment in the 22 SC case, because we'll just want to take care of those as well. And that'll get, oh yeah, because this was all, was it a pre? So Mr. Statum went into Veterans Court as a diversionary case. That's why there wasn't a, that case has been reactivated. It will be with me and you and he will figure out how to move forward on that.
Okay.
So yeah, I just need you to do a waiver of arraignment and I guess entry, whatever, on the 23 SC case, assuming that's what you and Mr. Statum want to do.
Yeah, I'll talk to him before he goes back down just to make sure.
Okay.
And that $13,000 bond should just come back.
It should, and if it doesn't, let's have a conversation about it and I'll see if I think that makes sense, given everything that's been going on in Mr. Statum's life and what's out there for him and what's not out there for him. But I won't take any action in either case other than to have Ms. Nelson lift the bench warrants or the FTAs in both those.
Okay.
And process will flow. If there are bonds and he can make them, then great. If he can't, we may need to talk about that.
Okay.
And obviously you and Mr. Statum will talk with Ms. Nix and Ms. Dilligard about how these might be resolved. All right. Mr. Statum, do you have any questions about what we've been discussing?
No, sir, I don't.
All right, so you've got two cases with me. One charges you with criminal damage to property and other things, and the other is an entering auto case. That one is from 21. And this one, the arrest incident date was 23, so it's a little bit newer. Both of them are kind of old, but you've been out of commission because of the revocation.
Yes, sir.
In what service branch did you serve?
I did 7 years in the Army, Judge, Your Honor.
Were you deployed overseas?
I went to Korea, but never for combat. I never
Okay.
served in the combat, sir.
All right, were you up at the DMZ or you were?
I was at Camp Hovey, right in back at Camp Casey.
Okay, all right. Well, Mr. Statum, I will see you in the new year once Ms. Rios has figured out what's happening with your bonds and whatnot. There'll be a scheduling order in place in both those cases, so they'll start moving. There's no reason for us to go slowly. They're old cases and the charges aren't particularly serious. So we can move as quickly as you and Ms. Rios are comfortable moving.
Yes, sir.
All right, thank you, Ms. Rios.
Thank you, sir.
Go back and talk to you.
And I guess, Ms. Rios, just touch base with Ms. Dilligard about discovery. I don't know if it was transmitted. I guess it would be in your file. It's not like you weren't here back in 2022, so.
If someone's kicked out of a veterans court, can they still go to drug court?
Yes, but there would need to be a whole intake thing. I don't know why he was terminated. They'll have it in their file, but it may well be that that would be the next track. That veterans would say that didn't work so well. It's the same curriculum, if you will, but
Yeah.
that's certainly something to explore, looking at the nature of these offenses. If addiction is what's behind this for Mr. Statum. So that's where we are.
I think that's all. I'm gonna go talk about the plea sheet and then I'll be back and ready to take the plea.
Okay, well, why don't we have Mr. Hiles, so why don't we have Mr. Jackson come out and talk about whether this is happening today or we need to set down a hearing, and that way he'll hear that. And then we can take a break while you talk with Ms. Bullock. Does that work? Okay, Ms. Willingham, you're here today too?
Yes, for Ms. Bullock.
Oh, for Ms. Bullock, okay, great.
I think that's all my cases. May I be excused?
Yes, you may. You are gonna spend some time doing a super helpful handoff with Ms. Dilligard. Excellent. Have at it. Tell her how wonderful it is in here. Right, Rios is the nice one, Wood is the mean one.
Right.
Hey, Mr. Jackson, come on out to the podium, please. Good morning.
Good morning.
I haven't seen you in a long time. Mr. Jackson, I signed a couple warrants for probation warrants for you back in September. And it's alleged in the warrants that in March of this year, you committed some new crimes relating to having a firearm and maybe having tools that are used for the commission of a crime. That's all I know. I don't need you to say I did it, didn't do it, you got it all wrong. But getting in trouble, or at least getting arrested for something, is a basis to have your probation revoked. So I signed the warrant, which doesn't revoke your probation, it just says, hey, we need to have a hearing. This is your first appearance with me on that warrant. And so I need to learn from your lawyer, Ms. Rios, who's standing next to you, and Mr. Hiles, who's seated behind you. Is this something that we're working out today because you're going to admit you were arrested and whatever the state's recommending is something you're good with? Or is this one where you're going to want to have a hearing because, and I'm making it up, the state is saying, well, we want to revoke 3 years. And you don't want 3 years revoked. And if that's not what you want, the state actually has to prove something. I don't just sign a piece of paper. They need to prove that in March of this year, you did whatever said here, you had a gun or you had tools that are used to commit a crime. They don't have to prove it beyond a reasonable doubt, like at a trial, but they still have to prove it. And witnesses have to come in and your lawyer gets to cross-examine those witnesses. You can testify if you want to. And we do that sometimes with revocations, not always, but sometimes. So that's what I need to figure out today is, do we need to have a hearing like that, which would be on a different day, or are we working it out, which would be today? All right. Ms. Rios, have you had a chance to talk with Mr. Hiles?
No.
No. Okay. Mr. Hiles, have you had a chance to look at this situation and develop a perspective from the state as to what the state would be recommending?
So the recommendation is based off of the original charge, more so than the rearrest. It was an unbelievable deal that was long negotiated.
Were you the negotiator or was it a predecessor?
I took over at the end because there was one old indictment. And then when we got looking into it, there was a series of unindicteds that were accused in 22. And then
so it was the 18 SC that was out there, and then research showed, gosh, there's some unincorporated business here, and that led to the 22 SC accusation.
correct.
Okay.
And then those were consolidated first for purposes of, I guess, trial, and then you took first offender on both.
Oh, it's a first offender situation. Okay.
And so one, I think technically I need to file a petition to revoke and resentence. And then, but secondly, I've gotten a little bit of warrants. I don't know the whole thing, but it's, anyways, the recommendation would be to revoke and resentence to 2010.
Okay.
And
That's a big number.
yes.
All right. So we need to have a hearing, Mr. Jackson, so that the state has to prove this up. I can learn more about the seriousness or lack of seriousness of these allegations if they are proven, because then I need to figure out, well, what's the consequence if the state does prove it up? Does that make sense?
Yes, sir.
Okay, you have questions about that?
Yes, sir.
No? Ms. Rios, anything on behalf of Mr. Jackson?
No, Your Honor.
Okay. Discovery is the wrong word, but what I want to avoid is we have a hearing and Ms. Rios is learning the contours of what happened in March through the witness. I'm assuming you'll prep it and be getting a police report or something like that.
There's a lot I gotta get. I don't think it'll take me too long to get it. I've got the incident numbers from warrants.
Mhm.
And so I'll be shooting out some emails today. I'm really not expecting much in response until honestly first of the year.
No, me neither. I mean, based on what the allegation is, it could be as simple as we pulled the car over and this was in the car. I don't know anything about it, but you may not need 14 witnesses either. Okay, all right. Well, if you would just commit to getting to Ms. Rios as you get paperwork, like just the basic police reports and whatnot, so she knows what it's all about. Okay. All right. Ms. Rios, anything else on behalf of Mr. Jackson?
No, Your Honor.
All right, so we'll get you back here as soon as we can. We need to set a date so that the witnesses can be here, and more important from your side, so that Ms. Rios can get some of the paperwork about whatever this was or wasn't, so she's in a good position to handle it for you, okay?
Yes, sir.
All right, thank you. Thank you, Mr. Hiles.
Yes, take care.
Will do. See you guys in the new year. Unless we have an emergency plea tomorrow in your case.
So, Israel. I wouldn't mad, it's not mad, it was just like, I'll have to pull the transfer of the plea, but I think I said, if he violates this, I will ask you for something. It's like, stolen 6 or 7 Land Rovers, we reduced the trafficking in here like that. And that's just one case.
So are you saying that in case it's not
No, I don't know, it's not the, like, just because you have a gun, maybe this would have been a recommendation. I don't know.
All right, so I need to break you guys up because you need to talk to your person so we can take the plea. And Mr. Howes, I need you please to let Ms. Nelson know how much time you need for the hearing so we can fit it in. We don't want to block out 30 minutes and for whatever good reason, it needs to take 3 hours. And so it'll be easier for Ms. Nelson to find a spot for it in the new year, once you've got a sense. But I know that'll take a little bit, but please do, once you get a sense of is 2 witnesses is an hour max, whatever the number is, let Ms. Nelson know. So unless you already can forecast that,
I don't think
it wouldn't be more than an hour.
I couldn't see it taking more than an hour based off of the little information I know, but I'll let you know for sure.
Okay, sounds good. Thank you. All right, so all that's left is the plea. The Court of Appeals just said that your office cannot keep the Trump case. What?
Yeah. In the room chat.
It just blew up on my screen. Interesting.
Mr. Peoples took time out of his busy day to notify us in our group chat.
From his federal job?
Yes. So Mr. Peoples is no, he's gone. What? No, we're actually gonna be in the same office. Even though, Judge, guess what, came open on the 12th of this month?
Something at the U.S. Attorney's Office?
5.
5 spots?
Yes.
So apply.
I did.
Good.
Deadline is today and I did it this morning.
Good. Get your foot in the door and start letting them know who you are.
Yes.
Yes.
That's nice.
Judge McBurney, I have
Yes,
some
ma'am.
information about Warren Bird.
Oh, I was fast.
So the reason why he wasn't handled yesterday is because he is still in Brady and looked out, and it does say he was loaned out, and apparently he's still there, so.
Okay, that would be then why Ms. Ivy, who is my contact at the jail, said, what can we do about this? That we can't even move his case forward because he's at Grady. And so he's one of those compassionate release situations. And so I don't know if he has bond in the Judge McAfee case that he's made, or if he's in custody from that, because another scenario would be to contemplate setting aside the probation warrant, because that's clearly one thing holding him in. But the jail is concerned that should he stabilize at Grady, he goes back to the jail where he can't adequately be cared for, and then and by stabilized, I mean more physically, not, I know there's a mental health component, but their main concern was the physical health component. Because I think he's at Grady for physical health issues, even though he's got both. I don't know what the status of bond is in the Judge McAfee case. But maybe if, I'm happy to see if Judge McAfee will just give me authority to manage his part of it. But if you could figure out the bond piece there, or your counterpart, whoever it is, to
Yeah,
say.
emailing Richard Marks, who handled the case yesterday, and they said that that's why he wasn't able to talk to him, because he wasn't brought over.
He wasn't even brought over. Okay, all right. Well, let's just stay in touch on that. If you're ready with Ms. Bullock, let's do that. Ms. Cabrera, I've got your waiver and entry, so we're good there.
Yes, and so I know Megan is having a person.
And that person was here, Ms. Dilligard. I don't know.
I'll
Okay.
figure it out and see if, I don't know, if we can.
When I sent that email this morning, I was still under the impression, Megan had said, I'm here through the end of January.
Right.
Ms. Dilligard showed up and said, Monday's her first day. So why don't I send, let me see if I still have, I've still got your email. So I'm gonna resend my response, and I'll loop in Ms. Dilligard, who's not gonna know anything about the case, but will be the person that you need to work with.
Yeah.
Okay.
Maybe that, he has no record, so it may be something that we can find a way to resolve faster than.
Ms. Ford has no record?
No, not Ford, for Mr. Matthews.
Oh, we switched gears, okay.
Yeah.
But it'll also be Ms. Dilligard. She will be
Right,
the
so
one
we'll-
trying to help with the debrief of your other client.
Right.
She doesn't know anything about that case. This one is simpler, I think.
Right, and I think that this one, we may be able to get a resolution and get him moved on. And as far as Ms. Ford, once Ms. Ford can get her proper done, I think we can get her moved on.
Right,
So,
because that sounds like it's more about the Mr. Murphy.
correct. So, but I'll send them, a message. and
Okay.
Figure something out.
Great, sounds good.
Thank you.
Happy holidays.
Yes, happy.
Okay, let's get on the record in 24 SC 000035, State versus Bullock. Good morning, Ms. Bullock.
Good morning.
How are you?
I'm doing fine, Judge.
Good. Ms. Bullock, you are out here because Ms. Rios told me that you were interested in entering a plea in your case. Is that correct?
Yes, sir.
Okay, for that to work, Ms. Willingham, who's the prosecutor on your case, is going to put you under oath. She's going to ask you a bunch of questions about your rights, things like that. You need to answer those truthfully and completely. If you've got any questions of your own, you need to make sure you let Ms. Rios or me know that you have a question. Will you do that?
Yes, sir.
All right, Ms. Willingham?
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your name and your age.
Sharika Bullock, 34.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
You said your age real quickly. I need to write it down.
34.
34, thank you.
How far did you go in school?
GED.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
You understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that count 1, aggravated battery, which has a minimum of 3 years and a maximum of 20, you would be entering a plea of guilty to that count for a 3-year probation sentence. You would be required to have no contact with the victim, complete family violence intervention program, have no weapons, no drugs, no alcohol, complete a mental health evaluation, and follow any recommendations.
Yes, ma'am.
And count 2 of the indictment, which is also an aggravated battery charge, would be null pros. Is this what was explained to you by your attorney?
Yes, ma'am.
You are now pleading guilty today to aggravated battery. As discussed, it has a minimum of 3 years and a maximum of 20 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
North Carolina, but it's parole.
What are you paroled for out of North Carolina?
Having marijuana.
So you went to prison for a while in North Carolina?
No, it's no, it's not parole, it's probation.
It's
but
probation.
It's not what you call it?
Not reporting?
Yeah, I don't have to report.
Okay. So the authorities in North Carolina know you're in Georgia. They're
Yes,
okay with that.
they expedited me back to Georgia.
Okay, got it.
Do you understand by pleading guilty today that your probation may be revoked?
Yes, ma'am.
You heard me tell the court what the negotiation is in this case, which is 3 years probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 20 years in custody?
Yes, ma'am.
You understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today.
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation.
Yes, ma'am.
You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as previously discussed, you would be required to have no contact with the victim, complete family violence intervention program, have no weapons, no drugs, no alcohol, complete a mental health evaluation, and follow the recommendations of that evaluation.
Yes, ma'am.
Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offense to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You have 4 years to file this petition. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Do you further understand, because this is a family violence charge, if you are found in possession of a firearm, you could also be charged federally?
Yes, ma'am.
Should this case proceed to trial, the state would expect to show that on May 6, 2021, College Park officers responded to a domestic disturbance at 4874 Old National in Fulton County. They met with the victim, Dominique Clark, who stated that she was pushed into a door and violently slammed to the floor, causing her shoulder to bend almost completely backwards. Officers observed a laceration to her head. The defendant was on scene, irate, and denied the allegations. The victim also at that time reported prior incidents of DV, including a strangulation. She stated that she still, at the time our office spoke with her, she still was unable to fully use her arm. She is no longer in this state.
Ms. Clark is no longer in this.
Correct.
Okay.
But I have spoken with her, Judge, and when I reached out to her, we initially couldn't get in contact with her. We had to kind of go through some different channels to get her. And when we finally did reach someone that knew her, she called us back actually very upset. When she initially spoke with our office, she made it clear that she didn't want anyone to know where she was. So I think her realizing that we were able to locate her upset her. She actually wanted me to dismiss the case. She actually texted me this morning again to see what happened with it. And I told her that I wasn't willing to dismiss it at that time, but I would be willing to try and offer probation to resolve it. She was actually also very upset to find out that the defendant was in custody on a bench warrant. So I explained to her again that, you know, it was the defendant's responsibility at that point to appear for court. She didn't, but that we would try and resolve it. So at this time, that is why the state is trying to get the case resolved.
Okay, thank you.
And that concludes everything from state. I'm sorry, I forgot to put that part on.
Okay, got it. Pre-trial, good morning. Can you please share any criminal history information you have for Ms. Bullock?
Yes, Your Honor, there's a total of 11 arrest cycles. This was the first arrest out of Georgia. There were 10 out of North Carolina. There's a 2007 felony conviction for child abuse out of North Carolina. Nothing further to report.
All right, thank you. Ms. Bullock, I'm gonna hear from Ms. Rios in just a moment, but I wanna make sure we're not setting you up for a little bit of frustration up front. Are you planning on going back to North Carolina?
Not right now at the moment, sir.
Not right away. Okay, good, because your probation can be transferred to North Carolina. That takes a little while. And so if you were thinking, great, I get out, I'm off to Charlotte, wherever you'd be going, you actually have to be in Georgia for a while in order for your probation to be transferred. But it sounds like you're gonna stay in state.
Yes, sir.
It's much simpler. Ms. Rios.
Yes, Your Honor. Ms. Bullock's 34 years old. She was working in North Carolina paving roads. She's going to be able to work back here at Labor Fine. Her fiance is here with
There's a whole bunch of cute little ones.
So she'll be living with her in Union City, and she'll be able to provide the court with the address for probation. And so I'm asking you to accept the plea as negotiated.
Okay. Ms. Bullock, anything you want to add?
I just apologize to the court, Your Honor. That's it.
Okay, you don't have to apologize to me. It sounds like you and Ms. Clark have gone separate ways, which is the most important part. She wants to be left alone and she's now not in Georgia and we'll all leave her alone now. Sounds like she wasn't happy that Ms. Willingham was just doing her job and reaching out to her. The three children who are here, are they your kids, your stepkids? How will they?
Stepkids.
They'll be stepkids in your life. And what's the age range?
9, 5, and 10.
All right, that's great. And how long have you two been together?
4 years.
4 years, but this happened 3 years ago. Ms. Clark was sort of a side
Three and a
situation.
half years.
Okay, all right. I'm not crying. I want to make sure we're not creating issues at home. Okay. Well, Ms. Bullock, I find there is a factual basis for your plea. This happened a long time ago, and ideally we would have addressed this a long time ago, but sometimes cases move slowly. It sounds like you've been staying out of trouble since this situation with Ms. Clark. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Any questions about anything?
No, sir.
And voluntary just means no one's forcing you to do this. You've decided this is how you want to move forward. Is that correct?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a little issue, and I'm making this up, but let's say you test positive for something once, you and probation will work through that. If you get arrested for something, or Ms. Clark is able to give to the district attorney's office evidence that you were trying to text her or anything like that, that's what I would view as a serious violation. That comes back to me. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
Ms. Bullock, is it okay if we electronically sign your name on the indictment? It shows your plea to count 1 and the dismissal of count 2?
Sir.
We will do that. Do you have a weapons carry license out of Georgia?
I don't carry no weapons no more, Your Honor.
Okay, and that means you don't have a license?
No, sir.
Okay, I don't mean a driver's license, but a weapons carry license?
No.
Okay, and you're staying in Georgia. Ms. Bullock, on count 1, I'm going to sentence you to 3 years to serve 6 months. And you've served 6 months, you've served 179 days with a balance on probation. So you have a little bit less probation. You get credit for the time you've been in. You did a bunch of time early on when you got arrested. And then the bail project posted bond for you. And then you've done a day more than a month, since you got picked up on a bench warrant. Special conditions of probation. The most important one is no contact with Ms. Clark. Don't reach out to her. Don't connect with her through someone who's a shared friend. Hey, just let her know I'm sorry, or I'm gonna hit you with a pan next time I see you. Nothing like that. If it comes back to you, that's a problem. You'll need to complete a family violence intervention program. That's not just one class, it's a series of classes. You need to do all of them, but that'll help you manage situations when you and someone you care about get mad at each other. It will be techniques different than whatever happened with you and Ms. Clark back in May of 21. And then you'll need to submit to a mental health evaluation. And if that interaction with a medical professional says, hey, it'd be good if you got some counseling or took this medicine, that treatment that the doctor recommends will become part of your probation, the actual condition that you need to follow.
I'm on mental health medication right now.
Great. Well, this is just then a check-in, and I hope the answer is you should keep taking it or take something different. But I'm glad that you're treating whatever the situation is and just maintain that treatment. Okay.
Sir.
I think that's it. Ms. Willingham, anything else in connection with Ms. Bullock's case?
Nothing from the state.
Ms. Rios?
No, Your Honor.
All right, Ms. Bullock, good luck with things, and you will be home for Christmas with your big family over there, okay? Oh, right, and then this is Officer Evans. She will not be your probation officer, but she is with probation and is just gonna get basic contact information because you'll need to report to probation. I'm gonna let her tell you when, but it's pretty soon after you get released.
Okay.
All right? Thank you. So, is that your last plea ever as an assistant DA?
Well, I don't know.
There's
if we can
tomorrow.
get if we can get some things worked out before the January 7th calendar, then.
Oh, because you'll be here on January
I'll be here.
7th?
My last day is the 8th.
Oh, that's
And
right.
I am
Okay.
gonna.
Because you're not taking time off.
So kind of, sort of, it's Christmas, so today when I leave, I'll be off, cause tomorrow's my birthday, so I'll be off until the 2nd.
birthday.
Thank you.
That's great.
I'll be off until the 2nd.
Yeah.
Whatever my version of off looks like.
Right.
And then I'll
Well, it
come
won't
back
mean
to
you
the
getting
8th.
ready for trials. I mean, that's a
Right,
nice thing.
so
It may
that's
be,
the big thing, is there are no trials to get ready for.
yeah. So there's
I am-
administrative work you'd be doing
Yes,
just to
and
have
I'm
a clean
just
hand
making
up.
sure that I leave whoever comes behind me. I'm gonna work on one order of proof. I'm not gonna like prep the case, but
Mm-hmm.
I just wanna make sure stuff that I anticipate coming up quickly.
Yeah,
People already have a starting block.
okay.
So-
Did you have any homicides remaining in here?
Yes, but it's the one that Tanya Miller was on. I can't think. of
Oh,
the
that's
name
my
right now.
oldest jail case now, one of my oldest jail cases where now,
The middle
Ted Johnson is,
female,
yeah.
yes. And Ted Johnson never responded to me and Miss Nelson, so I'm not really sure.
That case is stuck. It's gonna pop back up again and
It's
they need to
on
do
for,
something.
I think we have it on.
It's on the January
7th
trial calendar.
for
Oh, is it on?
status.
Okay, good.
It's not on the trial calendar, I don't
Okay.
think, but it was on, so.
For
we could
status, so we
kinda-
can see what the heck's going
So we can
on.
figure out what's going on, and the family knows because the mom wants to say bye, so she's gonna be here.
Oh, the family of the deceased.
Of the deceased,
Okay.
yes. So
The
she'll
family
be
on the other
here.
side needs to let Rios and Wood take that case because it is
They
going
really
nowhere.
do. It's not moving.
No,
It's not moving at all.
and he's not moving. Hairston is his
Yes,
name.
Harrison.
And he is not gonna move until there's a trial.
Yes, and whenever that trial is, I plan to try and sneak over and
Pop
sit
in. You got connected with the family.
I did. I actually have her picture up on my board, so.
Okay.
But that's the only one I technically have. There is one on the, trial calendar in January though, but it was the one that I had a conflict with. So I don't know if Abigail Potter's keeping it.
You had a
or not.
conflict as in you were busy or you
Yes.
have like, you
No,
know
no,
someone?
I was
Okay.
busy. I was supposed to be trying another case, so I had. to
Oh, and
figure
we were
out-
gonna send, I think we were gonna send it to Emerson. I dealt something with Ms. Potter on that, but it
Yes,
didn't,
but
okay.
then I think it was gonna conflict.
I
with
swapped
Lacey
it,
because she
yeah.
was gonna be
Yeah.
on leave.
Yeah.
Yes.
Okay, sounds good.
And by the way, that case, so I tried to explain, but I wanna double check with you. You don't go in order necessarily of the trial. So just because it says 15 doesn't mean it's like position 15.
No, right. But what we have is, you've been to it before, we'll have that
Yes.
meeting and we'll talk about it, and you all will be able to say, hey, that would need to go second week, or the detective is out and I take it off. And then I try to also communicate, it's not official at that point, it'll be in the email after the call account. I'm like, all right, that's the one you should be ready for.
Well, that's what I was under the impression of still, but.
Yep, hadn't changed. All right.
See you all next year. Yeah. Yeah. Oh, yes.